So, great, recording is in progress. Thank you, Tessa. Thank you, everyone, for kind of giving us an hour of your evening to join us on this little online Zoom. My name is Catherine, and I'm the Operations Director at North Wales Community Law. And I'm going to kind of set the scene very briefly, explain who we are and introduce our speakers. But before I do that, for anyone who wasn't here when I first mentioned it, please make sure your mic is muted, as usual, if you're not speaking at any particular point. And just to let you know that we are recording this session, and it will be sent to people who kind of signed up but weren't able to make it, and also made available on our website. So if you would prefer to keep your camera off, that's absolutely fine, although I seem to love to see you. So I'm really thrilled to have all of our speakers here tonight and to see so many of you, and to have you kind of give up a bit of your Thursday to join us for what I'm sure will be a really kind of interesting discussion on an important topic of making rights a reality here in North Wales. Thanks to our friends at Legal Action Group for helping to set and host the event, particularly excellent Tessa. And again, thanks to each of our speakers for agreeing to take part in this conversation and share with us your particular perspectives on the differences between rights on paper and rights in practice in Wales, and the challenges of helping people uphold their rights, particularly here in North Wales, and what we can do to overcome some of those challenges. So we're going to hear from each of our speakers in turn, before we then, kind of in the last third of the session, open up a Q&A, take some questions, and hopefully kind of facilitate what I hope will be a real discussion, and one that everyone is able to join in with. And we will finish at 7:30 because we all have things to be getting on with. So before I introduce our first speaker very briefly, I thought it would be helpful for those of you who don't know to tell you a bit about North Wales Community Law, and kind of what prompted us to set up this event. So we're a relatively new charity set up to address the lack of kind of free and accessible legal advice in North Wales, and to help people experiencing poverty and discrimination and injustice uphold their rights. We began taking clients for the first time in October of last year, focusing initially on housing, and we very quickly discovered this kind of huge gap between rights and protections in law and the day-to-day realities and experiences of people living in our community. And there are lots of kind of factors that have led to those gaps that I think are shared across England and Wales. Not least huge cuts to legal aid funding. But some of those I think are specific to Wales, and some are specific to North Wales, like kind of how those changes to legal aid have affected the ecosystem of private law firms doing legal aid work, and how that's interacting with kind of increasingly divergent laws, the Renting Homes Wales Act being an example of that. So kind of recognising that gap, we've brought together this panel of lawyers and non-lawyers, myself included in the latter, to discuss the role of law in realising people's rights, holding public bodies to account, and some of the way that we can overcome those gaps between rights on paper and rights in practice. So without taking up any more of your time, I will introduce our first speaker. Now, Owain, are you able to join us at this point, or I know Matthew was prepared to speak first if you weren't able to, so I'm happy to do it whichever way around you prefer.
No, I'm here and I'm
Great.
ready, willing, and able to speak. I was late because I was in Haverfordwest today.
Oh, great.
The car broke down yesterday, so I was on the train, and really going to the heart of one of the issues about the difficulties of access to justice in Wales. The train, albeit just from Neath across to Haverfordwest is still 2 hours or so, and I was 20 minutes late before I'd even stepped on a train. So apologies for that, but I'm glad I managed to make it in time. I was going to just speak very briefly about housing law and renting homes Wales, and touch on some slightly broader bits that Matthew and I have worked on from a sort of a housing perspective. And I mean, renting homes Wales in many ways brings a number of opportunities. Firstly, for contract holders, what would have been tenants a few years ago, to take matters to court through a dozen or 15 or so avenues under the Act. It's quite an accessible Act on the face of it, in terms of being able to seek redress, the court having a specific role, and the county court, for example, having power to review decisions on public law grounds. So on its face, it's quite a useful tool for contract holders and for lawyers. The reality, of course, is that in the main, most of those routes to court won't have the benefit of legal aid, because they don't involve possession proceedings, and that does in reality mean that individuals are on their own in terms of seeking redress. And that's, I think, probably most apparent at the moment with ongoing litigation in respect of fitness for human habitation, where it is landlords seeking declaratory relief. So you don't have, perhaps as the Act envisages, individuals, contract holders enforcing their own rights, seeking damages, seeking compensation, seeking declarations, but rather the other way around, somewhat ironically, of landlords seeking declarations from the court as to what their rights and obligations are in order to protect themselves. Now, there's nothing obviously inherently wrong with that, but it does, I think, identify the fact that there is something of a chasm between rights in theory, in principle, and enforcing them in practice. I mean, Matthew and I think we've probably gone back a couple of years ago now, dealt with quite an interesting unlawful eviction case where, surprisingly, if not astonishingly, the defendant respondent local authorities' response to Matthew's pre-action protocol letter, which alleged that they were failing to consider, yet alone actually using their statutory powers to prosecute landlords for unlawful eviction, responded very candidly, in fairness to them, saying, well, of course we don't do that, because nobody in the team knows how to do it. And as things transpired, the individual who had expertise and experience had left the team. They hadn't bothered, frankly, to replace him or her, and had taken the view that they could sit back and do nothing. In the event they conceded the claim that they were acting unlawfully in failing to even consider what to do, and farmed that work out to private solicitors, who in the end, I think Matthew did bring a prosecution. So there's rights are there, statutory powers on the part of public bodies to protect individuals are there, but they're not always used, and some might say that they're not often used. I was speaking with someone of housing law silk recently, who was questioning why there are so few decisions from the higher court or appellate cases in Wales, because there's actually quite a lot of really interesting little points to be taken. And I think the answer to that is probably quite a complex one. But the obvious one is, firstly, just the real difficulty with accessing legal advice and legal aid generally. And that's just fundamental. Even if something doesn't go anywhere, at the very least, it gives practitioners an idea of what the issues are and what the problems are on the ground. There's another point which you may or may not agree with, but there's a general feeling, I think, a general sense that civic society in Wales is quite small, and it's not particularly litigious as a community, as a society, and people are generally quite nervous about litigating. Local authorities and government are also generally quite nervous about responding to litigation, and you tend to see the sort of the legal litigation big guns being wheeled out far sooner and far readier in Wales than you might do across the border with local authorities in England. And anecdotally, at least, I think that probably does have an effect on stymieing appeals, stymieing claims and cases that do make their way up to the higher courts. That does leave, I think, a bit of a gap, because I know, looking at Crash, the work that we were doing on Renting Homes Wales 18 months or so ago, it's very difficult to advise on things when there is just very little, if any, guidance from the higher courts on any issues of principle. And we're now, 18 months or so on, and there still is essentially nothing at all of use. It is important that people are aware of what their rights are. It is important that people are able to access advice. And I think it is important that people do take those difficult points. People are prepared to argue those borderline cases, which, if not successful for individuals enforcing their rights, can often either identify broader issues, systemic issues, or at the very least provide some guidance and some assistance to those that follow. So in terms of housing law in Wales and enforcing rights, there's a lot there. There's a number of opportunities there, but I think there's a long way to go in practical terms in enforcing and giving real teeth to those routes to court which are in the Renting Homes Wales Act. So those are my that's my sort of overview and my thoughts for what it's worth.
That's really helpful and interesting, Owain. Thank you. And I think the things that you've mentioned about the kind of lack of guidance for some of this legislation, kind of lack of test and of a caution around litigating and responding to litigation is certainly, I think, reflected in the experience that we've had at North Wales Community Law in the kind of when we've been advising clients that we've had. I guess I'm curious to know if you, how would you like to see that change, and do you have a path that you think Wales can take to try and bring some of that kind of legislation to life? And I mean, nobody wants a more litigious society, but having, people having access to justice and having those points in law tested and being able to enforce their rights more than they are now.
I mean, I think, civic society being quite close isn't necessarily a bad thing. I think the access to government in principle is a very good thing. It means that problems can be dealt with early, can be identified and can be solved early. And so I don't necessarily think that is always a bad thing. But I think there's often a feeling that people don't want to rock the boat because one way or another, especially in terms of funding, all roads lead back to Cathays Park, and you will have often, third sector organisations, women's rights organisations, for example, where there's real nervousness and concern about taking difficult points and about rocking the boat. I mean, I think fundamentally the reality is that that isn't what will happen. You know, if people take genuine points, and the reality is that is what they often are. You know, these aren't people taking silly points for point scoring purposes, but you know, if people take these points, I mean, I suspect that there would be maybe a little bit of sort of cooling of litigation generally. People won't be so shocked and appalled that they're being challenged, you know, be that government or local authorities. And I think it would probably lead to a slightly more constructive approach, where there's a realization of, well, actually, there is some ambiguity or confusion in the legislation. And actually, the only real way of answering and resolving that is by seeking answers from the courts. You know, it is helpful to have correspondence and messages coming down from ministers and Welsh Government to the sector, which is what happens, and it helps. But that doesn't answer the fundamental question of, well, what is the meaning? What's the proper interpretation of this legislation? And at some point, that, you know, that narrow point of what does this actually mean is an issue that has to be decided for a particular individual. And if it's somebody that's particularly vulnerable, or somebody who lives, you know, mid Wales, difficult logistically, practically to obtain advice. Often it just means that the point isn't taken, and usually that's to the detriment of the individual. Very rarely is it to the detriment of local authority or RSL or Welsh Government. So not necessarily a bad thing, but I think seeing and recognising the benefit of, as opposed to just the difficulty caused by litigation, is probably something that would be useful in general.
Thank you. I feel like I could ask you questions and kind of chew over this for a while, but I'm conscious that there are other people that we would like to hear from before we move on to kind of taking questions and having a further discussion at the end. So in that kind of vein, thank you, Owain, for now, and let's come back to some of those themes, and I'm sure they'll kind of crop up, and I've certainly made some notes when we discuss things as a whole later on. But our next speaker is Matthew Court, who is a lawyer for Wales for Public Law Project. And as Owain mentioned, Owain and Matthew have worked together on things, and I'm sure continue to. And I know that Matthew has done work that spans all of Wales, but you know, certainly has done work undertaken in and for North Wales too. So Matthew, if you're ready, please introduce yourself, and I'll hand over to you.
Yeah, sure. Thank you, Catherine. So I'm Matthew Court. I'm a lawyer for the Public Law Project. For those of you that don't know, Public Law Project is a charity that has a team of researchers and lawyers, kind of looks at all things public law and judicial review. So our casework team will bring judicial review challenges on behalf of individuals and sometimes on behalf of charities to challenge decisions by public bodies such as the DWP, the Home Office, Legal Aid Agency, and the Welsh Government, which is about this case that I'm going to talk about to you now. So what I've been asked to speak to you in the 10 minutes that I've got is about a recent success with Wales specific legislation. And so the case that I want to talk to you about is one that's quite recently wrapped up in relation to the Welsh Government's decision to stop providing free school meals provision over the school holidays. And so this case relied on a number of grounds, but there were two grounds in particular that relied on Welsh specific law. So we had one ground of challenge which relied on what we said was a breach of the Rights of Children and Young Persons Wales measure. And then another ground of challenge which relied on, again, we said a breach of the Equality Act 2010 Statutory Duties Wales Regulations 2011. I can explain a bit more about what they actually mean in a bit. So the case was partially successful in that the Welsh Government did eventually admit that it's acted unlawfully in the way that it stopped the provision of free school meals over the holidays. And the High Court declared that to be the case as well, by consent. Unfortunately, the provision wasn't reinstated for a number of reasons, but it was still a good judgment for the claimants, and one that I hope has some further impact in relation to how the Welsh Government approaches children's rights in Wales. But just by way of a background, so basically this all kind of started in March 2020. So obviously during the COVID pandemic, so schools were closed. The Welsh Government, to its credit, and I think the same happened possibly in England as well, decided to provide free school meal, or the equivalent of free school meal support, to eligible children whilst the schools were closed. So that was in the form of kind of vouchers, sometimes money paid into the parent's bank account, and each local authority in Wales was kind of given the power to distribute that support in the way that it kind of seemed fit. Move forward a little bit further, sort of around April 2020, schools starting to kind of reopen and kids going back to school. And so those children that were eligible for free school meals could then get them again in school. Again, the Welsh Government, again to its credit, decided that when it was going to continue the support whilst during the school holidays. So normally, obviously, if you're in charge of free school meals, you get it whilst you're in school. Once the school holidays were upon us, you kind of don't get that support anymore. But the Welsh Government, sort of as a bit of a COVID measure, kind of still sort of putting that support in place, decided that it was going to provide free school meal equivalent support during the school holidays. And this kind of happened sort of from school holiday to school holiday, kind of kept getting extended by the Welsh Government, and it kind of morphed into more of a kind of cost of living crisis kind of support. And then, so what would happen is the Welsh Government would kind of find a pot of money, put this support in place for the school holidays. The next school holidays would kind of start to come around again. The Welsh Government would look for some more money. Oh, we found some more money, put the support in place again. And this kind of rolled on for about 3 years, until just before the summer holidays of last year, so 2023, the Welsh Government, only a matter of kind of days or weeks at best, decided that it wasn't going to provide the support anymore and just terminated it. And obviously this was to the dismay of a lot of charities that work in the field of children's rights, obviously the parents that were getting the support. It was a very unpopular decision, not only because it was withdrawing support, which a lot of people had got used to, but just the way that it was taken with very little notice before the school holidays were about to start in summer 2023. So we were approached by a number of potential claimants who wanted to challenge the way that decision had been taken. And so we were approached by 3 individuals, or 3 families. So our first client, who didn't actually go on to issue the claim in the end, she had to kind of drop out for personal reasons. But the first client that we were approached by and that we advised was an asylum seeker who'd moved to Wales during the pandemic with her children, victim of domestic abuse, very vulnerable, obviously on asylum support, so very little income. And so that free school meal support over the holidays was invaluable to her. The second client that we had was a Nigerian family with 4 children. Father studying to be a nurse in Wales, so again, low-income family on universal credit, became quite dependent on the support that was in place during the school holidays. And then the third client that we had was of a family of 6 children, so multiple disabilities within the family. So lots of the children had some learning difficulties. The father had quite severe disabilities because of a stroke that he'd suffered a few years previously, so wasn't able to work. So again, on low income, and become very dependent on this free school meal support during the school holidays that was, without much notice, just kind of ripped away just before the summer holidays of 2023. And so we brought a judicial review challenge on their behalf on the basis of 3 grounds. So the first ground was that there was a breach of Section 1 of the Rights of Children and Young Persons Wales Measure 2011. So what Section 1 of that measure says, that it places a duty on the Welsh ministers to have due regard to certain parts of the United Nations Convention on the Rights of the Child when exercising any of its functions. And so there's various articles within that convention. For example, Article 3, which requires that all actions concerning children, so in all actions concerning children, their best interests should be the primary consideration. And what we said and what the claimants argued was that there was no evidence whatsoever that the Welsh ministers had due regard to the convention before taking that decision to withdraw the free school meal support. There was no documentation they could provide to show that they'd had due regard, such as the child rights impact assessment, which is an assessment obviously of the impact of the decision on children, which is not a legal duty to complete, but it's kind of expected. And the Welsh government's own policy documents say that it's expected that if you're going to make a decision that impacts children, you should carry out a child rights impact assessment. They hadn't done that, and they quite readily admitted they hadn't done so. Our second ground of challenge wasn't relying on Welsh specific law, but it was in relation to a breach of the public sector equality duty under the Equality Act 2010, which applies to both England and Wales. But basically what we said that there'd been a failure of the Welsh ministers to have due regard to the impact of that decision on people with protected characteristics, such as people with disabilities, single mothers, ethnic minorities, for example. And again, the Welsh ministers couldn't point to anything to say they had such due regard to that public sector equality duty. And then the third ground of challenge was in relation to a failure to consult based on both common law and also a breach of regulations 5 and 8 of the Equality Act, statutory duties Wales regulations 2011. And so what those regulations are for, the purpose of those regulations, is to enable the better performance by the Welsh ministers of the public sector equality duty. So it's kind of linked to ground 2 in a way. And it says that the Welsh ministers must consider the impact of any proposed policy or practice on its ability to comply with the public sector equality duty. And the way that it does that is that it kind of is meant to carry out consultation exercises, engage with people that have got protected characteristics or with organisations that have an interest in the way that the public authority or the Welsh ministers in this case are carrying out their functions. And we said that it failed to do that. It failed to consult, it failed to engage with anybody before it took this decision to remove the support for free school meals. The outcome of the case was that it was successful on grounds 1 and 2, wasn't successful on grounds 3, which was the consultation ground. And so after much toing and froing and very late in the day, the Welsh ministers did admit that they had breached section 1 of the children's rights measure, and they hadn't had due regard to the public sector equality duty and the impact that decision was going to have on people with protected characteristics. And so by consent, the High Court declared that was the case. Ground 3 at the very last minute wasn't pursued, and that was because there's an ouster clause which no one actually noticed until the very last minute in the Equality Act 2006 that says that proceedings in relation to a breach of the specific duties can only be brought by the Equality and Human Rights Commission. And so unfortunately our clients didn't have the standing to bring a challenge in that respect, so that ground was dropped, unfortunately. Where do I think that kind of leaves us? I mean, like I've said, the support wasn't reinstated because the Welsh minister said, well, you know, we don't have the money. They did their equality impacts assessment in relation to a later decision and said that we've done all our assessments. We know the decision is going to be poor, it's going to impact children, but we've satisfied the due regard duty and therefore we don't need to put the support in place again, which was disappointing, obviously. But I think, you know, this case demonstrates that there is opportunity to use Welsh specific law to uphold people's rights and hold public bodies to account. And I think there's many other opportunities to use Welsh specific law, such as these children's rights measures, but also section 1 of the Equality Act, which is in relation to socioeconomic inequalities, which is enforced in Wales but not enforced in England. You know, the certain international human rights conventions that have indirect status in Wales that don't, the same is not, cannot be said for England. So you've got the United Nations Principles on Older Persons, for example, which is indirectly incorporated through the Social Services and Wellbeing Act in Wales. So there's lots of opportunities, I think, to use this kind of Welsh specific law to kind of hold public bodies to account. That's my 10 minutes, so I'll wrap it up there.
That was perfect timing, Matthew. I was so enthralled by what you were saying that I only just looked at the clock. I was like, oh, I've not been paying attention to the time. So thank you for being so on it yourself. That's really interesting. It's really nice to get into the kind of detail and the personal sort of storytelling of that particular case and the people involved. And to hear about kind of the Welsh specific legislation that that helped you get there. I was partly out of my own nosiness, really. I'm curious to know how those clients found their way to you.
So one was referred to us by a charity working in Wales with migrants. So that was how the first client came to us. The second client came to us, actually how he was an existing client who we'd acted for in a previous matter. So he was known to us and we were known to him. And the third one came to us self-referred after seeing an article in the BBC about the case. So yeah.
Really interesting. Well, thank you again. Let's park some of those themes, and it's interesting to see how those things might overlap with some of the things that we heard from kind of Owain earlier. It is exactly 7:05, which on my little list of notes means that it is precisely time for us to welcome Wendy and hear from Wendy Dearden, who is Senior Policy and Research Officer with a particular focus around housing at the Bevan Foundation. So Wendy, if you're ready, I'll hand over to you.
I feel under huge pressure now to come in at exactly 10 minutes, which is a really hard thing for me to do when I'm talking about housing after 27 years working in it. And compared to, I was at the Senedd yesterday, and there's an inquiry into social housing supply. Yes, and I will not be going into the detail and depth that we did in that hour-long session tonight, don't worry. I've just put a link to our website in the chat because you may want to go and have a look at that. And I am going to do a presentation just because it will keep me on track of what I'm actually meant to be talking to you about. And I like a pretty picture along the way as well. And you don't really want to look at me for the whole 10 minutes. So let me see.
While you're sitting it out, Wendy, I'll kind of politely wave at you when we're approaching your 10 minutes. Or maybe just ping you a note.
Right. Can you see lots of purple and orange, everybody?
I can indeed.
Lovely. So I've only been at the Bevan Foundation since the end of February. My job before that was Policy and Public Affairs Manager at Shelter Cymru. And I kind of feel like I've got a foot in both the old camp and the new camp at this point. So I might reflect when I'm talking on some of the casework and the campaigns we were doing as part of my Shelter Cymru work as well. All in all, if you cut me through as a piece of rock, then I've always done housing work, starting in local authorities. So yeah, can draw a lot across a load, far too many jobs than I care to remember at this point, all in the realm of housing and just trying to secure appropriate accommodation for everybody that needs it. Now, it works. You've probably, given the profession that you're all in, know Shelter Cymru very well. You may not know the Bevan Foundation quite so well. So the Bevan Foundation, we describe ourselves as Wales's most influential think tank. Given that the general election has just been called, I need to stress that we are totally independent. So although we take our name from an A in Bevan, then we're not aligned to any political party. And I was very firmly told about our rules in terms of the general election this morning, so I'm very aware of what I'm saying. We develop solutions to tackling poverty and inequality, and we're very much known, so the whole thing about free school meals, childcare, housing benefit, but the benefit system in general. We've also got a project at the moment about no recourse to public funds. So whatever your area of interest, it's well worth going onto our website and seeing what's going on at the moment. But we also do quite a lot of work in the housing sector, and that's why I was brought in, because we've got some new projects. In terms of work that we've already done in that space, we've looked a lot at local housing allowance, so the maximum amount of housing benefit you can get in the private rented sector, and we've crunched numbers and shown the inadequacy of it against private sector rents. We've also done quite a lot of work looking at the holiday rental market, particularly Airbnb, and the impact that has on housing in local communities. But the new project that I've been brought in for is all about unlocking social housing. When we say unlocking social housing, not only unlocking the blockages to accessing it, as well as unlocking the blockages to actually providing it full stop. So unlocking has two elements to that. And I feel like I need to mention our funders at this point. So we're very grateful to the Lloyds Bank Foundation and Nationwide Foundation for funding me basically for a 3-year period to do this work. Depending on your specialities, you may be more aware of the legislation and duties on local authorities around temporary accommodation or not. And really it's the starting point of our project. So when we talk about temporary accommodation, we're talking about short term, and I'm putting that in speech marks because short term doesn't necessarily mean short term at the moment. Short term accommodation used by local authorities to fulfill their homelessness duties. We are at record levels. I keep kind of looking to say if I can still say record every time the things come out. We've kind of bobbed up and down. That graph I've stolen from a previous presentation, that only takes us to September 2023, but the February 2024, which is the most recent figure from local authorities, is the 11,721 individuals across Wales who are in temporary accommodation. If we look pre-pandemic, December 2020, then we were well over half of that figure. So it's just going up and up and up and up. Catrin also asked me to give us a North Wales element. I'm based in Conwy. I'm just across the river. I can wave at her across the river if it wasn't quite so grim this today and cloudy. You might think of this as kind of an urban issue, a Cardiff, Newport, Swansea type issue, but we've got about 2,500 individuals across the North Wales authorities. And the thing that we focus a lot on at the Bevan Foundation is the number of children involved in that as well. It's going to be a little bit doom and gloom, I'm just warning you. Also, we do a lot of research, snapshots of poverty surveys, and the last one of that, which was done January this year, said that 14% of people in Wales are worried about their housing security, both in terms of eviction or repossession. So there's no sign really of those numbers going down anytime soon in terms of people being threatened with homelessness because of the various things going on in our housing system. Okay, so in terms of discharging that duty to provide temporary accommodation, traditionally we would have been looking at the social rented sector. However, a change was made in the Housing Brackets Wales 2014 Act. Really feel I need to get that right because there's lots of lawyers in the room. That said that duty could also be discharged into the private rented sector. In terms of social rent, we've now got, again, a record 139,000 people on social housing waiting lists. To give you a bit of a scale of that, there's only 240,000 homes across Wales. Okay, the 139 is talking about individuals, but I would say at least 50% of social housing waiting lists are as single people. Then the other issue, so in terms of social rent is like gold dust at the moment to get a key to a social rented property. Then we've got all the stuff we know going on in the private renting sector in terms of high demand, rocketing rents, and then the controversial question of the impact of greater regulation through the Renting Homes Act, Rent Smart Wales and compulsory registration. Whether you agree that landlords have been exiting the market or not, or whether there's evidence for that, you can certainly say that the private rented sector has been in a place of turbulation that hasn't particularly been a secure place for tenants to be whilst all this extra regulation has been coming in. So the Welsh Government has set a target. They set the target back in 2021 at the beginning of the term of the Senedd to develop 20,000 homes in the social rented sector. We're not just talking social rented homes. It's complicated, this definition. It includes things called intermediate rents and also shared ownership. But we'll gloss over that. That's for another presentation and another day. Generally, that 20,000 homes would require 4,000 to be delivered each year. In the first 2 years, we managed 5,775. So the ambition is there to get social housing built at scale. However, in reality, and going back to the rights to accommodation, the need for accommodation, but the reality of exercising those rights in practice, there are lots and lots of barriers going on in the sector at the moment, which are preventing social homes being built at scale. Cost, both in terms of supply, but also the other challenges housing associations have in terms of decarbonisation of their stock, energy efficiency and higher standards. Just accessing land, the cost of land, the availability of land, and also the complexity of the planning system. When also in terms of different statutory consultees, the public sector purse is really, really stretched at the moment. So those public sector consultees are all looking at the planning system to help to deliver their bit. And all of those extra costs on top can make housing schemes unviable. That was the main crux of the discussion at the Senedd yesterday, and we had a whole hour on that. So 3 little pictures in a quick couple of minutes. I'm not really doing it justice.
Just to flag, Wendy, that's your 10 minutes. So
Okay,
please do continue.
This is my last one.
Oh, wow, that's great.
I'm doing pretty well. So we've got all that going on in terms of we need more social homes. There is a right to accommodation. People are living in particularly bad conditions. A third of people in temporary accommodation are in bed and breakfast, hotel rooms. It could be a whole family sharing. So there's lots of talk at the moment about the adequacy of housing and the housing safety net, as we call it, and the holes within it. At the same time as that, you've got a challenge going, and the 3 organisations, TypeHow, Shelter Cymru and CIH Cymru, talking about the right to adequate housing. So this is enshrined in international law, and when we talk about adequate, we're talking about everything from security to the roof doesn't leak to affordability. It's enshrined in international law. However, some countries have taken that a step further to have it incorporated into, I'm going to call it domestic law. We've had a green paper in terms of that in Welsh Government, and we're currently sitting back and waiting for a white paper in that space as well. The main concern, or if you sit in a stakeholder meeting with that, with local authorities and housing associations, they're saying, well, if there was that right, how would we ever be able to meet it under current resources? The final 2 slides, which I'm going to flick through because it's being recorded so you can go back to it, is if you want further information about the Bevan Foundation, then please go and find us online, and we have various newsletters that you can sign up to. And if you'd like to talk to me more about housing, because it is my mastermind topic, and I'll talk to anybody who is interested at all in the issues of our housing market, then that's my email address. And I will stop sharing at that point to give Catherine comfort that I'm all done.
That was brilliant. Thank you, Wendy. Again, really interesting and nice to have another perspective on some of these issues. And I think the question you raised at the end there about public bodies, councils asking themselves how they would kind of meet these standards if this right to adequate housing were a thing, is exactly kind of the same questions that underpin, the same issues that underpin the things that Matthew and Owain have spoken about earlier, so thanks for that. Okay, so we have just over 10 minutes for kind of questions, discussions. So I really want to throw this open to all of the people attending. And if our speakers would like to ask questions of each other, that's also completely fine too. So if you do have a question, can we raise our hands in Zoom? I'm sure we can. I'm a Teams girl myself, so I'm now struggling to find out where it is. But I guess otherwise, just pop your mic on and say hi, ask a question. Let's have a couple of minutes of uncomfortable silence while I let everyone ask their question.
I raised my hand, but I don't know if it's showing. Perhaps just to get the ball rolling, I think one of the things in the context of tenants enforcing their rights that can be challenging even under Renting Homes Wales is that people feel insecure about their housing situation. There's still this imbalance of power between tenants and landlords. And I thought, those statistics that Wendy shared were particularly striking about how insecure people feel about possession being sought, even in the social housing sector. And so I was wondering, what reflections do people have, and what might be good ways to encourage people to understand and bring cases to court to establish their rights and raise awareness of their rights, while also recognizing that asymmetry of power. Is it looking for situations which people are a bit more secure, or where possession seedings have already been brought, and you've got an opportunity to bring counterclaims or defences in that context?
I'll sort of chip in for what it is. I think there was quite an interesting opportunity, and I don't think it's completely off the cards, but I think there's quite an interesting opportunity for a Renting Homes Wales tribunal type system to be adopted, so that there's a specialist tribunal that's informal, cheap, accessible, dealing specifically with housing matters. And I think that sort of approach would probably sort of revolutionise how housing issues are litigated, because at the moment you've got almost both ends of the spectrum. You've got the legal aid, Shelter Cymru possession proceedings end of things, and on the other end of the scale you have frankly, claims farmers doing no win, no fee work where costs end up being 10 times the amount of damages that individuals received. And when you have that sort of polar opposite, it's quite difficult really for everybody to engage in a meaningful manner, or in a manner which they feel safe. So I think it's finding the balance in terms of access to justice, but doing it in a way where, as you say, maybe the imbalance of power is dealt with. And again, fundamentally, I do think it comes down to access to advice and access to justice. And if there are slightly different ways of doing that in Wales, then I think that's something that would be quite interesting to explore.
That's great, Owain, thank you. That's a really interesting idea. Renting Homes Wales Tribunal, I think, revolutionises the word. Wendy, I know that you've got your hand up. I can see a hand.
I was just going to jump in that whatever the law says, or whatever help there is in terms of helping with fees, the wider context to supply is always going to be a major influence on whether people choose to step forward and challenge. And whilst we have that huge demand in the private rented sector, I won't get on to no fault evictions today, because again, that's another huge subject. But until people feel more secure in their place in the sector, or have more options of where else they could go to, it's a fundamental issue with our system, regardless of what the law or the financial cost might be.
What I think is interesting, Wendy, is that listening to people who have kind of sought housing advice from us in the last few months, is that people know that, people are really aware of that too. So they know that they might have a case. They know that they might be able to get help with costs. They're willing to bring it, but ultimately they know the result is going to be, it's going to have an impact on their housing situation that doesn't necessarily serve them in the long run, or they're going to be, find themselves in a very similar situation somewhere else. So I think that's a.
And it's also potentially a very sought after house next door or in the same street as their mum, where their kids are settled in school. There's a whole context within which they're making those decisions.
Yeah, thanks, Wendy. And thanks, Crash, for your question. Did Owain answer your question? Do we have any other questions? People, please do feel free to use the brains that we have in the room to ask these people there.
I was just going to ask something. I mean,
Hi,
really,
Sean. Sorry, I didn't see your hand there, but
no,
thank
no,
you.
that's fine. Yes, I've only just worked out how to do that. I mean, I was just wondering if anyone can answer whether there are any sort of discussions at a legislative level in Wales about the idea that instead of using the county court, having a tribunal that deals with the housing issues, there's a whole practice directions worth of different applications that can be made under the Renting Homes Act that are all dealt with by the county court. And I can't believe half of them have been ever used at all. And possibly they might be used at a tribunal where they wouldn't be used in the county court. It would possibly be a bit faster. But is anyone actually thinking about that? And aligned to that, and I suppose that's the no-fault evictions thing, is, you know, there's been lots of publicity about the what was hoped to happen in England, getting rid of the Section 21. Has there been any discussion again at a legislative level about getting rid of no-fault evictions in Wales? I mean, I don't know the answer to either of those things.
I think there's I'm not sure if it's still open, but either very recently or currently there's a consultation into the Welsh tribunals, which I think generally is viewed as being quite an effective, quite an effective sort of system to date in the areas that the Welsh tribunals sit. Whether that's expanded to cover housing or elements of housing matters, I don't know. I don't know whether the others have their fingers on the political pulse more than I do.
There was an appetite to ban no-fault evictions during my time at Shelter Cymru, and a bit of a U-turn about that not appearing in the Renting Homes Act, very much like we're seeing with the Renters Reform Bill. Cabinet Secretary recently has said that actually tenants in Wales have greater security than in England or Scotland because of the 6-month notice period now. So that's been her latest view on no-fault evictions, and it's not something that is being actively pursued as a specific policy area at the moment, as far as I'm aware.
I mean, I think there were concerns around Article 1, Protocol 1 challenges, which sort of underpinned that, which makes the power imbalance point that Crash mentioned quite an interesting one, doesn't it? It's not only contract holder against landlord, but also potentially landlord against government, which is quite an interesting one. But
thanks, Owain and Wendy, and thanks for the questions, Sean. If anyone has any burning questions, we have 3 minutes left, so now is the time to raise them. I can't see any hands, and that might be my screen, so if you do have a question and I'm not hearing you, just turn your mic on and shout out. Otherwise, I'm going to take a couple of minutes just to say thanks again to all of our speakers for joining us. Thanks to people who did ask questions and kind of helped us continue that conversation. If making rights in a reality in North Wales is something that you're interested in, something that floats your boat, which I'm guessing it is since you're here, then you might be interested to know that we are, I think it'd be worth you having a look at our website in terms of what we're up to at the moment. We are currently looking for trustees, and I think there may be people on this call, otherwise in your networks, that I think could bring us some really helpful additional skills. And we're also recruiting, so we have some paid posts that we're recruiting for at the moment, and I'll put a link to our website in the chat for anyone who's interested in those. lastly, just to say that, as I mentioned, a recording of this session is going to be sent out to everybody who signed up for the session. So you will get the pleasure of being able to hear your voice or see your face back on a recording if you were lucky enough to make an appearance. And you know, obviously for people who sort of were expressed an interest but weren't able to make it on the night. And we're also going to put it up on our website. If you have any questions or kind of curiosities about North Wales community law and our work, I'm also going to put my email address in the chat, so you can, I'm spelling as I'm speaking, so you know, please do get in touch. Feel free to send me an email, or you know, pick up our phone number off the website and sort of get in touch. I'm a dork for this stuff, and I've been, you know, the sort of the trustees and I have been working on helping to increase access to justice in North Wales for a while, and yeah, I could happily chat with anyone about it. So thanks again for joining us. It's 7:30 now, so I'm going to say goodbye to everyone and wish you all a really lovely evening. Thanks, everyone.